Hello, this is Matt on the Moon Lambeau channel. The SEC is now insisting that Ripple produce internal documents. It was really, certainly, at least initially supposed to be confidential between Ripple and their attorneys, having to do with the degree to which they understood there was a risk of XRP being determined to be a security by the SEC. So these would be secret documents, internal, the business of nobody outside of there, in all likelihood, unless, of course, they started publicly sharing that, which is a question. I'm not so sure that's necessarily the case, but that could potentially change things. Now, this news comes one day after the SEC, frankly, got their ass handed to them by the judge yet again, after they were trying to get around this order, court order that during a pretrial hearing, mind you, this all came to be, that the SEC must produce documents, internal documents, showing how they came to conclude the legal statuses of Bitcoin, Ethereum, and XRP. Now, they didn't want that, of course, because you can only imagine the stuff that they said. I'm hoping that there's a skeleton in the closet somewhere, some sort of smoking gun, but we won't know until, well, if we see a settlement sooner than later, that could be a strong indication. So there's certainly a possibility of that. But either way, this is going to make their court case much harder, as I articulated in a video I put out just yesterday. And so now you got the SEC here hitting back. So I'm going to share with you opinions from two attorneys within the XRP community that today spoke on this topic, giving their perspective, the implications of all of this. But ultimately, it does seem to me like it's just the SEC continuing to be a bunch of baby back biatches, because that's really just what they are. I do want to be clear at the outset, though, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast making YouTube videos as a super duper fun hobby about Ripple and XRP and crypto, and that is all that's going on here. And so here you can see a headline from crypto media outlet U Today. SEC wants to force Ripple to testify about legal advice it obtained regarding XRP's legal status. And so, actually, you know where I want to jump first? Let's go back to, because I want to make sure we got the table properly set, because some of what we're talking about here, if you don't have proper context and understanding, it's just not going to mean as much to you. And so if you go back to the SEC's initial filing on December 22nd of last year, 2020, against Ripple, you can see the case that they're attempting to make on this particular topic. They're basically, what they're getting at here is that Ripple was told, this is what they want you to believe anyway, that Ripple was told that XRP was a security back in the day, back in like whatever it was, 2012, and that they went forward and sold this unregistered security even though they knew better. That's effectively the message that they want to get across. But that is not in line with reality. It simply is not. But here is what the SEC wrote in this official initial court filing against Ripple December 22nd last year. So here, there's a little section titled, Ripple's lawyers warned Ripple and Larson, so that would be Ripple co-founder Chris Larson, that XRP could be a security. Ripple sought the advice of an international law firm regarding certain state and federal legal risks associated with the distribution and monetization of XRP. The law firm provided two memos, one on February 8th, 2012, and another on October 19th, 2012, that analyzed these risks. The first memo was addressed to the co-founder and another individual, and the second to Larson, the co-founder of Ripple. And Ripple also. The legal memos warned that there was some risk that XRP would be considered an investment contract and thus a security under the federal securities laws depending on various factors. So think about that. They're basically saying that because the SEC could bring an argument, just the fact that they could argue something means that somehow, that just the mere fact that an argument is being brought forward, that the arguments and logic behind it must be so. It must be truthful. It must be accurate. That logic does not follow. It doesn't make sense. Because think about that. So the mere fact of making a claim makes it so. Well, what about on the other side? Somebody that says that the way that Ripple was initially positioning XRP would not make sense to characterize that as some sort of investment contract. So logically, you could. Why is it more true for the SEC and not for Ripple if they were to make that argument? The logic simply there does not follow. And consider this too: the mere claim that XRP is a security does not make it a security, and the mere threat, understanding that there's a threat that the SEC could make an argument that doesn't make logical sense, understanding there was a risk of the SEC making an illogical argument, that doesn't mean that what they did was wrong. It doesn't mean that they believed moving forward what they ultimately ended up doing would have been wrong. The logic does not follow. But they want you to believe that what they're spouting here makes some sort of sense, and it simply does not. We're not stupid here. And then they wrote the following. And as far as the scenarios in which perhaps XRP could be considered an investment contract. These included, among other things, how Ripple promoted and marketed XRP to potential purchasers, the motivation of such purchasers, and Ripple's other activities with respect to XRP. So to be clear there, they're wording it in such a way that they're trying to make you think that Ripple knowingly did these things, when really these documents, all it would cite there is if things are done in a particular way, then XRP could potentially be argued to have been an investment contract. There's no sort of indication that Ripple did whatever those things are, and so the argument the SEC is making here does not make sense. They also wrote, if individuals purchase XRP to engage in speculative investment trading, or if Ripple employees promoted XRP as potentially increasing in price, the legal memos warned that Ripple would face an increased risk that XRP units would be considered investment contracts. So again, risks doesn't mean that it is the case. The fact that the SEC has brought this argument, which they have now, does not mean that what they are arguing is based in reality. That there was always a risk that they could have argued something that wasn't based in reality. Now we're seeing that become unfortunately a reality right here. And check this out too. I love this part. Both memos warned that XRP was unlikely to be Both memos warned that XRP was unlikely to be considered a currency under the Exchange Act because, unlike traditional currencies, XRP was not backed by a central government and was not legal tender. Now, this is interesting because XRP has now been declared after mind you, Ripple and Larson, they were warned that XRP, assuming this is true, XRP would likely not be considered a security. What happened 3 years later? XRP was declared did I say security? I might have said that wrong. Let me reword it again just in case. Ripple and Chris Larson were warned in 2012 that XRP was unlikely to be considered a currency. Okay, what happened 3 years later? XRP was declared a currency. It actually was. I'm not kidding you. So here's the piece from, this is written up by FinCEN. This is their actual website here. Take a look at this. The Financial Crimes Enforcement Network, working in coordination with the U.S. Attorney's Office for the Northern District of California, assessed a $700,000 civil money penalty today against Ripple Labs, Inc. I'm not going to talk about that in this video. I've covered it in the past, but anyway. And its wholly owned subsidiary XRP2 LLC. Ripple Labs willfully violated several requirements of the Bank Secrecy Act by acting as a money services business and selling its virtual currency known as XRP without registering with FinCEN, and by failing to implement and maintain an adequate anti-money laundering program designed to protect its products from use by money launderers or so on and so forth. And so this is basically another instance of regulation through enforcement. But you did get some sort of clarity out of this, that XRP was a virtual currency. And so as it turns out, a virtual currency, basically virtual currencies as a result of this are put on the same level as traditional currencies because they're now being regulated in exactly the same way with the same requirements. And so if you go back here, if you think about this, the SEC is arguing that based on what Ripple's lawyers warned about how there could have been an argument brought indicating from the SEC indicating that XRP is a security, that should have been enough to for Ripple to not proceed with what they ultimately did. But it looks like the lawyer's advice, maybe it wasn't so good. I'm not saying the case. I'm just saying you could argue this. You could argue, why should we trust any of what the lawyers had to say? Because they said it was unlikely that XRP would be declared and regulated as a currency but it was declared a virtual currency and is regulated as a virtual currency, which is, again, the same regulatory requirements as a traditional currency also. So what we're supposed to trust half of what was stated to be likely in these internal memos from 9 years ago? SEC, you got to bring your A game. I'm not a lawyer, and I can see these logical flaws in the way that you're arguing here. Like, you got to bring your A game. Is this your A game? Not looking so hot here, frankly. And so here you can see crypto law, as well as James Filan was sharing the most recent document, which came out today, May 7th. And I'm going to get into the comments from two attorneys now on this, John Deaton and Jeremy Hogan. So here you can see SEC files motion to compel Ripple to produce documents regarding any legal advice Ripple sought or received regarding whether offers and sales of XRP would be in compliance with federal securities laws. And so here is what attorney John Deaton had to say about this. And I'm sure the vast majority of you are very familiar with John Deaton to this point. But for those of you not aware, he is the one that's seeking to file a class action lawsuit against the SEC because they're claiming that XRP today in our wallets is a security, not just that Ripple sold XRP as an investment contract. He's also filed a motion to intervene in the case of the SEC versus Ripple. And if granted, I mean, there's going to be a third party here, John Deaton, along with somewhere in the neighborhood of like 17,000 XRP holders that are not so happy with the SEC rather. And so here's what John Deaton had to say with this most recent legal filing from today. The SEC just filed this letter asking for a conference on whether Ripple must turn over the legal memos it received in 2012 about XRP and how, if marketed and sold in a specific manner, XRP could be considered an unregistered security. Back in January, I tweeted that the due process / lack of fair notice defense had real teeth. And let me pause right there. What he's talking about there is just this idea, and it is a real legal argument, and it is a strong legal argument, that Ripple was allowed to conduct business, and XRP ecosystem was allowed to get built out, all sorts of third parties building on top of the XRP ledger. XRP itself being used by all sorts of third parties, traded globally. All this was allowed under what seemed like tacit approval from the SEC for the better part of a decade. And so inaction, as it turns out, is a legit legal defense. So we're talking about here due process / lack of fair notice. And it's something you got to logically think through this. Because some people say, well, but the SEC, they were still putting their case together. I'm like, come on, after a decade? And at some point, don't you have to have a cutoff anyway, even if arbitrarily selected? Can you imagine if 100 years from now, XRP is flourishing, it's still global, but on a much bigger scale, and then the SEC comes, oh, gosh, yeah, for the last 100 years, just so you know, come on. Clearly, this XRP thing's it's an investment contract. XRP itself is a security. You've been doing this illegally for 100 years, right? So at some point you have to have a cutoff point, and I understand you may need to arbitrarily select something, but I think most logic-minded people that are unbiased would agree that when you're talking about close to a decade later, that is not remotely reasonable. Anyway, John Deaton continues now. This proves that the SEC also considers the defense a real threat. Oh yeah, the SEC definitely thinks that the due process lack of fair notice defense has teeth. And more from John now. Ripple has argued that the legal memos only show general advice that it's possible to utilize and sell XRP in a way that violates securities laws, but ultimately concludes that XRP itself isn't a security. Yeah, so that's a very great way of wording what I was citing just a few minutes ago. Because the way the SEC wrote it up, it's as though Ripple and executives were warned, hey, by their lawyers, hey, look, if you do this, just so you know, it's going to be a security. But that's not in line with reality. That is not what happened. They said, hey, XRP could be sold in such a way, perhaps, that there could be specific ways it could be sold that would be investment contracts. But XRP itself certainly isn't a security. That's not what their lawyers said. Anyway, John continues. Whether the judge will compel Ripple to turn over the memos is an interesting legal issue. Ripple is only raising the defense because it was sued by the SEC, so I don't believe just because Ripple is using it for one of its defenses, the SEC gets the documents in their entirety. The stronger argument for the SEC is that if Ripple shared the information to third parties, like investors, they waived the privilege. Regardless, the SEC is definitely worried about this defense. And so we'll just we'll just have to sit tight and see here. Now, I don't know to what degree, if any, Ripple circulated any of these memos outside of their, their top execs there. So, if for no other reason than, keeping that out of the court, because it's just another thing that doesn't need to be discussed. Hopefully, it wasn't distributed in any sort of way that would make it more likely to be discoverable. But we shall see. And then here's a comment on this from attorney Jeremy Hogan. I like John Deaton's analysis of this latest request from the SEC to see Ripple's legal opinion letters, RE XRP. Check it out. Also interesting to note that depositions start in about 2 weeks, including Brad and Chris, and no, depositions are not open to the public. So that's a shame. Well, I understand why. I mean, maybe it's not a shame, but just for me, my own personal curiosity, it's a shame, and probably yours too. It would be neat to see what's going on there. But whatever. Maybe we'll get some word through the grapevine, or there will be some sort of press release here and there. I don't know. Well, anything that's made public, though, we're going to be talking about here. I'm certainly going to be talking about it here on the Moon Lambo channel, but I will wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.